Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. I also have a great topic for you tonight, and it is going to be waivers. So immigration waivers that are available for certain immigration violations. So it's not the end for you. And it doesn't necessarily mean that you're going to be ineligible for an immigration benefit if you have an immigration violation in the past. There are waivers, and I like to refer to waivers as a type of pardon or a request for forgiveness for certain immigration violations that would maybe in your past. So immigration violations are going to include certain crimes. So crimes, what's called crimes involving moral turpitude. It's going to be certain crimes that involve, that add up to a total of 5 years in a sentence. So an aggregate sentence of 5 years. This is 2 or more offenses that add up to an aggregate sentence of 5 years or more. Also, drug offenses, but this is very limited. In this case, you can only get a waiver if you have a simple possession of marijuana that's 30 grams or less. So if you are outside of that, there is likely no waiver available for you there. Also, unlawful presence, and this is a common one where you may be in the country, you may have crossed the border without permission, or you may have overstayed and you're trying to figure out how to fix your status to then be able to still get an immigration benefit or a green card or work permit. So there are waivers that are available for situations like these, and you should get legal advice and representation to get you through this complex process. Not all crimes, not all immigration violations are going to necessarily render you inadmissible. For example, if you have been, if say you are about to apply for a benefit and you have you overstayed, but you did not pass 180 days. So you didn't go over 180 days. You were in the country for 180 days or less. What that means is that you have not accrued unlawful presence and you're not necessarily inadmissible. Let me give you an example how this could work to your benefit. So say you stayed 179 days in the United States, you overstayed your visa, and you were in the United States for 179 days. You went back to your country, assuming there are no other issues, and then you go to the embassy for your immigrant visa interview for a green card. The officer will then review how much time you spent in the United States without status. If it goes over 180 days, then you're barred for 3 years and you'll need a waiver. But if it's down to the exact mark of 179 or 180 days and you did not surpass 180 days, guess what? You don't need a waiver. You're not inadmissible, and that 3-year bar does not apply. So it's very important to get legal advice and representation because these small details can make such a big difference. You may not need the waiver. And so, for example, in a consultation with me, you can learn this information, whether you're going to need a waiver or not. And that would be great news for you. How long? So I'm going to answer some questions here. How long do you have to wait for your appointments in Guyana? So you would have to check. It depends on what the NVC is doing right now. Where are you in your case? What kind of visa are you applying for? Is it the immigrant visa? And so I wouldn't be able to tell you that. I would have to check the specific information related to Guyana. You can do that by going to the National Visa Center's website, or if you have a case that's pending, you can check with the embassy directly. I'm not your attorney, I'm not the attorney on your file, and so I wouldn't be able to have that very specific information. How long does USCIS take to process your EAD in marriage-based green card? So I'm seeing work permits being issued anywhere from 4 months to 11 months right now. LPR can't naturalize. Will spouse have a problem when he petitions? So your realtor, it's gonna depend. This is where it's very important to get a consultation and representation. And it's a good thing you're asking this question, because this could very well be related to the topic that I'm talking about, which is the waiver. If your spouse is a legal permanent resident and you overstayed, they are unable to naturalize, then that very well means that you may have to apply for what's called the Provisional Unlawful Presence Waiver. This is going to forgive the overstay and allow you to still fix your situation and still go on to get permanent resident. But this is not the same as adjustment of status, where you get to stay in the U.S. for the entire process. What would have to happen is the LPR spouse will need to submit the petition. When it's approved, then they go through the waiver process. All being well, the waiver is approved. Then it goes to it goes back to the embassy. The embassy schedules the appointment, and then you would be able to go to your country, attend the interview, and not have to face the consequences of the unlawful presence if you even need the waiver. So schedule the consultation, because then in this situation, it's going to be more complex, and the information I'm giving you is very general. The advice that you're going to get is going to come down to your specific facts. Yes, so that's 463. The long wait times for work permits is because of all the delays that have happened with COVID. Before, I was seeing about 4 to 6 months for the work permits, but now it's going, as I've had, the shortest is 4 months and the longest is 11 months. And the average I'm seeing right now is 6 months to 11 months. So hang tight on that and check on your case. Make sure they're not requesting anything from you. How can I file for divorce if my husband is not in the state, but I'm not a citizen? So Princess Nika Miller, that is more of a family question, family law question. I'm not a divorce attorney, so I wouldn't be able to answer that question. You will need to seek a divorce attorney in your state to figure out the best way that you can go about that divorce. Now, I'm a U.S. immigration attorney. I do practice in all 50 states, immigration law only though. It's a federal practice, which allows me to run a national practice. But when it comes on to family law, that's state specific, because the laws, the divorce laws, family laws, they differ from state to state. And so it is restricted to those that practice law within the state. I am barred in Minnesota, and I'm barred in Florida. However, I don't practice family law right now. They had requested my medical, but they not to send it until they said so I can still get my EAD. So Dance 463, that should still be in process, even though they requested the medical. The medical, it can be something that you even bring with you to the interview. So while they're encouraging you to send it right now, they're more flexible on when you can send it in. So the employment that's not going to delay your employment authorization card being issued to you. All right, great questions. Keep those questions coming. I am talking about waivers for certain immigration violations. So there are different types of waivers based on different situations. So for example, if you have a criminal background that allows you to get a waiver, then the waiver requirements are going to differ from, say, an unlawful presence waiver, where you will have to show extreme hardship of your qualifying relative if you don't get the green card. So, for example, if you are applying for, say you have a criminal offense, and that criminal offense is a crime involving moral turpitude, there are criminal waivers, and there are two ways to approach this. And keep in mind that if you're in the US already and you qualify for adjustment of status, you can stay in the US all the way through your process and also apply for the waiver. But the waiver here is going to, it depends. If it's been more than 15 years since the crime occurred, since your conviction, then you will just have to show that you have been rehabilitated, and granting you the waiver is not going to be against public interest in any way. However, if it's under 15 years since the last time you've gotten approved, then at that point you're going to have to show that you have a qualifying relative who will experience extreme hardship if you don't get this. And this is how you should think of this waiver. When we talk about extreme hardship, is what are the worst case scenarios that you think will happen? What are some devastating effects that your refusal of the green card or your inability to get the green card will cause your relative? Will your relative have to, for example, are they dependent on you financially? Do they have health issues? If they have to move to the country with you, for example, if you had a legal permanent resident spouse and they would have to move back to the country with you, what would happen then? Would they lose their job? Would they be able to get an equal job? Would they be able to get the kind of health benefits they get? So it's really case by case basis, but it is possible to prove extreme hardship if that relative, the qualifying relative, usually a U.S. citizen or legal permanent resident, spouse, a parent, in the criminal context, a U.S. citizen's son or daughter will experience extreme hardship. With unlawful presence, it's only down to your qualifying relatives are only going to be your U.S. citizen or legal permanent resident, spouse, or parent. So even the qualifying relatives are going to differ based on what type of waiver that you're applying for. The important thing here to know, though, is that you can, if you are in a bad situation here where you have a past conviction or you have an unlawful presence, there are options to be able to still fix your status and go on to get permanent resident. That's where you need to schedule the consultation to determine what options would best suit you. So applied for extension on B2 visa, went for fingerprint appointment, what's next? So you'll have to wait for a decision. That is usually what's next with the extension application. All right, so that is all I have for tonight. So I talked about different waivers, right? So there are waivers available if you have not, so these are the waivers that are available. If you have been convicted for crimes involving moral turpitude, there are waivers available. However, the first thing I would have to do is evaluate, does the crime, because even misdemeanors can cause one to be convicted for, can be categorized as a crime involving moral turpitude. So you can't assume that because it's a misdemeanor, it's not severe. Under immigration law, it may be severe. And so you should get a consultation to evaluate your case. But there are waivers available for that. If you have had misrepresentation or fraud, immigration misrepresentation or fraud, there are waivers for that. You have to have the qualifying relatives, which would be a U.S. citizen or a legal permanent resident, spouse or parent. If you have been convicted of 2 or more crimes with an aggregate sentence of 5 years or more, then that there may be a waiver for that. And the type of waiver you're going to choose is going to depend on how long ago was the crime, how long ago was the conviction, was it under 15 years or over 15 years ago. Then in the case of drug trafficking, there is no waiver unless you had a simple charge of possession of marijuana, 30 grams or less. And then unlawful presence. So there are waivers available for unlawful presence. I'm going to answer this question here too. I see VAWA was denied for not proving joint residency. Should I be concerned that my new case is back at Vermont? If VAWA was denied 5 years ago and a new marriage-based AOS is filed, why was it sent to Vermont? So I wouldn't be able to, now if it's not VAWA, it's not going to, if you are applying for a marriage-based and it was sent to Vermont, it's not going to be evaluated by the VAWA unit because it's not a VAWA case. But Canditi, I am not the attorney on your case, and I have no idea what your case looks like, what happened with the failure to prove joint residency. And so you would have to, if you want further advice and representation, because you should not, one thing with immigration law is don't do it yourself. It's not a DIY, or it shouldn't be, because immigration law is complex. And oftentimes individuals underestimate the process and end up getting deeper and deeper into it. So you should, if you got previously denied for something, I highly recommend you get representation in your next process to make sure that you understand the implications, that you understand any bumpy situations that you may encounter. And it sounds like here you have a lot of doubts and fears going into the next process after this denial. So don't do it by yourself. Make sure you understand, or you have someone like an attorney who understands. The consultation is $150 for up to an hour, but it is especially in your case, Canditi, it is well worth it. I mean, how much do you value your future in the United States? How much is it worth to you? That's the question here. The consultation is a small investment in your future because you get advice about how to move forward in your process, your options, and you get the option for legal representation after you get detailed legal advice. So think about that one. All right, so I don't see any questions. I'm both on YouTube and I am on TikTok, but I don't see any more questions. So I am going to head out for the night. Canditi, you're welcome, and I hope I can assist you soon. Now, I will be heading out, but I'm not finished. I'm going over to Instagram where I'm going to continue this live. You can join me there. I'm the immigration attorney, same as here, same as YouTube, same as TikTok. So you can hop on over there. If you go to the link in my bio on TikTok, you will see the button to go to the Instagram. That's where most of my videos are released on a daily basis. The videos are great because they give you short tidbits of information about ways you may qualify, immigration tips about the immigration process, and updates if any important updates come up. And then I do the live at 9:30 p.m. Eastern time. So I hope to see you in a minute. I hope to speak with you in a consultation, because remember, the information I've given you tonight is not legal advice. It's general information. Just one fact that's different could change everything for you. So make sure that you invest in your future here. Make that investment. Get legal advice. Don't do it yourself, especially if you are in doubt. Get the advice and representation you need. Have a great night, everyone. I will see you tomorrow at 9 p.m. Eastern time. So I'll see you here, 9 p.m. Eastern time. Good night.